All this is Dr. Mubin Sayed, and as promised, here is the part number two for the FDA's appearance in court over ivermectin statements. Tomorrow, I'll do the part number three and the last part. Today, the interesting thing to note is the FDA saying we were not doing any interference. You would see in the part number three tomorrow that at some point, the court, and I'm paraphrasing, court said that then why did all these organizations blocked the ivermectin or fired people or had all those actions? And FDA simply said that these are sophisticated organizations that can make their own decisions. So this reminds me of the Rube Goldberg machines. So let me very quickly show you the Wikipedia page, Rube Goldberg, and you may have seen those machines. Rube Goldberg, I believe, is the only person who is in dictionary with his full name. And the machines that he invented used to use complex methods to perform simple solutions. Here, I think that we may be looking at Rube Goldberg machine of complex structure to perform something that was not allowed. So I'm reserving my words here. So please look at this. This is the part one of the same discussion. That in the description of this video, this link is present. This is the hearing that I am presenting the transcript of. Somebody said to me that Facebook had, just now somebody said in the comments that Facebook has tagged this talk, last talk, as misinformation or fact checked it. Well, I am only reading the transcripts, so I do not know what did they fact check in there, maybe FDA's statements. This is the article that has become the basis of these discussions or the hearings, in addition to the tweet that you're not a horse, you're not a cow, you all stop it. So that tweet plus this, why you should not use ivermectin to treat or prevent COVID-19. And of course, there's tons more material. I wanted to quickly show you so that there is a context when you are reading or listening to their transcript. This is American Medical Association with American Pharmacist Association, with American Society of Health System Pharmacists, or ASHP. This is September 1st, 2021. They said, we strongly oppose the ordering, prescribing, or dispensing of ivermectin to prevent or treat COVID-19 outside of a clinical trial. So as much as FDA now says that a doctor has the authority, and solely the doctor has the authority for off-label use of drugs, here is a combined statement. And I remember that after this statement came out, many pharmacists and CVS's and Walgreens of the world, they had stopped filling ivermectin or start questioning ivermectin or start calling doctors for ivermectin. And I believe they do that to this date. So FDA says, hey, nothing to do with this. And I'm going to read out their transcript. I just want you to see the machine in action. Then here is American Medical Association saying why ivermectin should not be used to prevent or treat COVID-19. So imagine if FDA didn't say it, this is AMA practicing medicine. But if you see here, they say the Food and Drug Administration echoed the CDC's warning against the use of ivermectin for preventing of treatment of COVID-19. Why I'm presenting this to you is that in the transcript, you would see that FDA says that we never did this. We never said to anyone to stop. Then here is this is US news. American Medical Association, other groups warn against ivermectin use for COVID-19. And in here they say, the groups are joining similar calls from the Food and Drug Administration and the Centers for Disease Control and Prevention to stop the unapproved use of drug to treat and prevent COVID-19. So basically, this all was an attack on a doctor's authority to prescribe off-label. The attack was started from somewhere. Of course, the court would decide if FDA had anything to do with that or not. However, I think at least we all can see how this machine worked. So then here is American Medical Association again. What the FDA wants doctors to tell patients asking for ivermectin. This is, in my opinion, again, a suggestion for practicing medicine. Then here is November 4, 2021, Utah Society of Health System Pharmacists, where they say that, hey, FDA and CDC are proposing that we should not offer this. Then here, this is August 17, 2023, this month. Federal court says pharmacists can use independent judgment in filling prescriptions. So this is also in the context of ivermectin. So that machine is still working. Then here is, I think this is the strangest case of this ivermectin and COVID-related time. Strangest outcome you would see. This is California legislative information. This is the bill AB 2098, where they're saying physicians and surgeons unprofessional conduct. And in this bill, which has been signed, I think now it has been challenged as well. In this bill, I'm paraphrasing now, the bill is here, the link is in the description so you can read the actual thing. I've done past talks about this. In this bill, they are simply saying that it shall constitute unprofessional conduct for a physician and surgeon to disseminate misinformation or disinformation related to COVID-19, including false or misleading information regarding the nature and risk of the virus, its prevention and treatment, and the development, safety, and effectiveness of COVID-19 vaccines. California actually put this in law. So now somehow the lawyers, the lawmakers in California had a wild dream that what should they be doing here? So there has to be a boss somewhere providing some indications of how to operate. Then here, I also wanted to make sure that we look at this. Michael Crichton explains why there is no such thing as consensus science. The reason I brought this article up is that in here, in this California's law, they say misinformation means false information that is contradicted by contemporary scientific consensus, contrary to the standard of care. Contradicted by contemporary scientific consensus. A bunch of scientists or so-called scientists come together and they say, we all agree that this particular thing is a fact. So here is Michael talking about consensus. I want to pause here and talk about this notion of consensus and the rise of what has been called consensus science. I regard consensus science as an extremely pernicious development that ought to be stopped cold in its tracks. Historically, the claim of consensus has been the first refuge of scoundrels. It is a way to avoid debate by claiming that the matter is already settled. Whenever you hear the consensus of scientists agree on something or other, reach for your wallet because you are being had. Let's be clear, the work of science has nothing whatsoever to do with consensus. Consensus is a business of politics. Science, on the contrary, requires only one investigator who happens to be right, which means that he or she has results that are verifiable by reference to the real world. In science, consensus is irrelevant. What is relevant is reproducible results. The greatest scientists in history are great precisely because they broke with the consensus. And this person who wrote this article has given a bunch of examples here. This example always makes me thoughtful. This is when this scientist who had said that, so in this time, 1795, doctors or physicians used to perform autopsies on dead bodies, and then without washing their hands, they would go and deliver babies, and the result was babies would die, mothers would die. And so then this doctor, uh, Alexander Gordon, said that we should wash our hands. And remember that he was made fun of, and finally, because of saying that we should wash our hands after the autopsies, he was put in a mental ward where he died. So they killed him in a mental ward. So, with all of this context, let's look at the next part of the video. This is, again, this is the hearing. I'm not making up any of this here. This is the arguments in the court. So starting from 22 minutes 34 seconds, continuing for the last one. So remember, before this, we closed on this. The FDA said about their own statements, they said, these statements are not regulations. They have no legal consequences. They don't prohibit doctors from prescribing ivermectin to treat COVID or for any other purpose. Quite to the contrary, there are three instances I'd like to point the court to in the record that show that FDA explicitly recognizes that doctors do have the authority to prescribe ivermectin to treat COVID. So the kingpin, the big organization, is simply saying, well, we didn't say anything. We actually agree with and understand this. But the whole machine was working. So now they're saying, so the judge says, 2234, what is the answer to Judge Clement's question? What authority do they have to either recommend or not recommend off-label uses? To say that they weren't doing that is not the answer. So judge is saying to FDA that you are saying that you are not doing it. You are not making those statements is not the right answer. What we want to understand is, what is your authority? So they're saying, what is your authority? FDA response says, there are multiple sources of authority for FDA statements here. So FDA is charged by Congress with protecting the public health and ensuring that regulated medical products are safe and effective. This isn't, and the counsel was continuing when judge said that we can say give recommendations about off-label use based because it's charged by Congress. So they said that you are saying that you can make these recommendations because you are charged by Congress for health. FDA said, yes, Your Honor, FDA has inherent authority to further its mission by communicating information to the public about safe uses of drugs. And just to share another example, last fall there was a TikTok challenge that encouraged consumers to cook their chicken in NyQuil in a cough syrup, and FDA put out a statement saying this is not an FDA authorized use of the drug. This is an off-label use, then it's not safe. FDA has to be able to make these kinds of statements, these kinds of public safety statements. And under plaintiff's theory, FDA would not be able to communicate to the public in this way. So if you see here, judges are trying to figure out if FDA has the authority. And FDA is continuing to say, we are mandated by the Congress to make sure that drugs are safe and effective. These are very different point of views. The question is something else and the answer is something else. But you would see that judges continue to hammer this point because they want the answer. They want to understand more. So judge then says, is the FDA ever responsible for making these public statements? Can they, if they make statements that are false or grossly misleading or wrong, can they ever be held responsible? Or are they allowed to make statements whatever statements they want, without any oversight or ability to come against the FDA are they immunized for all of their statements? FDA says the FDA is not immunized. Judge says, well, I thought that we are here for sovereign immunity. So can they be held responsible when they make statements assuming arguendo that statements are grossly misleading, incomplete, factually scientifically wrong, with intent or negligently or grossly negligently or reckless? Can they be held responsible or liable? FDA. Your Honor, it's not the role of the court to police the statements of an agency charged by Congress with making sure that drugs are safe and effective. Can you imagine this? So, judge is trying to understand, can they make these statements and can they be held liable? Do they have sovereign immunity for saying whatever they want? That's what the judge is trying to figure out. And as FDA responds and says, Your Honor, it is not the role of the courts to police the statements of an agency charged by Congress with making sure that drugs are safe and effective. Can you just think about this answer? They're saying you cannot police us. Judge says, so is the answer no? They can't be held responsible? What is the answer to the question, please? Can they be held responsible if they make grossly incorrect statements, either due to negligence, recklessness, intentional behavior? Can they be held responsible or not under the law? Judge continues, I'm not asking what's morally right or good. I'm asking what does the law say? FDA says, the law does not say that it's the role of the court to police the scientific statements by the FDA. Sorry, I have actually copy pasted the transcript from the YouTube. So there are these spelling mistakes. For example, instead of FDA, FDI. But did you see what happened? Judge once again said, could you be responsible or held responsible? And the FDA said, the law does not say that it's the role of the court to police the scientific statements of the FDA. And about the scientific statement, we saw this last time in this transcript, that when the judges dug deeper into what was the science for the FDA, the only science that came up was we had the reports of hospitalizations. That is the science they presented here. I know that there are so many people who reached out to me saying, well, there is this study and there is that study and there is this weak evidence. This is what FDA is saying in the court. I am presenting what they are saying in the court. So they once again tell the judge that it is not the role of the courts to police the scientific statements of the FDA. And so we know now what does this scientific statement really mean here. So judge says, so is the answer no? They can't be held liable in court no matter whether their statements are false or true? Is that the answer? If that's the answer, then just say it. And FDA says, Your Honor, that's the answer. If the statements are merely communicating information to the public. So once again, they kind of put a qualifier on it that if the statements are merely communicating to the public. So they keep saying we are not providing medical advice, we're not practicing medicine, we're just saying things. In the beginning, they started with, we were just joking, these were just quips. Now they've come up with, these are informational statements. So FDA says, Your Honor, that's the answer. If the statements are merely communicating information to the public. So judge says, so no matter what the information is, and no matter whether it's false or it leads to even deaths, and I'm not saying this in this case, that I'm not saying in this case, I am saying hypothetically, they cannot be held liable for if they're giving information out. And FDA says that's correct because, and as she was continuing, judge said, so they are allowed to, by Congress or by someone has immunized them from being liable. Is it Congress? FDA says, and this is these were three judges. I believe Judge Clement was the one who asked most of the cases. So FDA says if the FDA is making informational statements, they do have sovereign immunity. So do you see the qualifier informational statement? The problem is that were these informational statements? Do you feel why you should not use ivermectin to treat COVID or prevent COVID-19? Is this information statement? And this is what judges are trying to figure out. Somebody was leaving comments that Dr. Mobeen doesn't understand these things. Fine. Judges are trying to understand it as well. So it is judges who are asking these questions. They are trying to become clear on this. So if the FDA is making information statements, they do have sovereign immunity. There is no waiver of sovereign immunity under the ultra-various doctrine or the APA. There can be circumstances FDA is issuing formal regulations. These regulations may be challenged under the EPA, but that's a different circumstance than what we have here. It would be, now check out again. So she has already made two statements that you cannot police us. Now check out the third statement. It would be extraordinary for this court to conclude that FDA needs explicit statutory authority merely to speak to the public. So do you see the, again, in my opinion, gaslighting here? Judges are trying to see that were you authorized, FDA, to say don't use ivermectin? That's the question. Even don't use horse ivermectin. Were they allowed to say these things? And FDA is doing, you can't police us. Well, we were just joking. And now they're saying it will be extraordinary for this court to conclude that FDA needs explicit statutory authority merely to speak to the public. So they are saying that we're just speaking to the public. What is your problem? I mean, that's my words. Agencies talk to the public all the time. That's how the government communicates with its constituents. They talk to the press, they go to the conferences, and they send speakers to speak on behalf of the agency. They issue statements on social media, and agencies need to be able to speak to the public like this. They have inherent authority to do so under Section 393 of the Federal Food and Drug and Cosmetic Act. And Congress also gave FDA explicit authority to make exactly these kind of statements. In Section 375B of the Federal Food and Drug and Cosmetic Act, in Section 2420 of the Public Health Services Act, judge says, this is so good. Judge says, but you can see the FDA has no authority to issue medical advice, correct? Thus, that's not arguable, right? FDA cannot issue medical advice. So now the judge is asking, once again, a straight question. And FDA says, no, Your Honor, the government isn't conceding that in this case. So they say, we don't want to discuss that we can issue medical advice or not. So then the judge says, you believe the FDA does have authority to issue medical advice? FDA says, the FDA, the same thing they're going to repeat. The FDA is charged by Congress with making sure that drugs are safe and effective. And FDA is entitled to have a view about whether drugs are being used in a way that is safe and effective. Sure, they have and if there are examples in the world as they were here, this I think was a very underhanded statement. There were examples in the world as they were here of consumers using drugs in ways that were not safe and that were leading to hospitalizations. It is not only permissible, it is imperative that FDA be able to inform the public of its scientific views about safe uses of drugs. Scientific views. In my opinion, FDA takes the word scientific as their ownership, that whatever they utter is going to be scientific. And we saw that their scientific view last time in the early part of the hearing was not really, in my opinion, now this is my opinion, was not very scientific. But because they uttered it, they think it is scientific. Judge says it doesn't matter whether they are scientific views or not, whether they've been tested scientifically or whether they're just views. Does that matter? Because judge is still hung on to this. And what is the science in here? FDA says there's nothing in the multiple sources of authority that I cited that requires the FDA to go through any sort of formal process. See how they show their colors every so often? That we don't need to show any formal process. Last time they said we don't track any formal process for science. And as much as people are jumping up and down saying that there is this science and that study, the thing is inside the court is what we're hearing. And here they said there were reports of hospitalizations. So there is nothing in the multiple sources of authority that I cited that require the FDA to go through any sort of formal process. Judge says, can they give a dating advice or only advice about drugs? FDA says, because Congress has charged the FDA with protecting the public health by ensuring that drugs are safe and effective, FDA can give information and advice about drugs. I'm not aware of anything that, so I think she was going to continue about the dating advice. And judge says, but that would be medical advice, right? And then there is some inaudible part there. But I think the judge said FDA is not authorized to give medical advice. Judge continues, I think the line is, what is the line between giving advice about drugs, as you put it, and the medical advice? FDA says, so I think it would be helpful to look at the statutory text of Section 393 if that's what your honor is asking about. This is a very important part. To start, 393 specifically refers to devices and not to drugs. So FDA is saying, well, we only have this authority for devices, not for drugs. And 396 discusses the authority of a doctor to prescribe. So here, they're saying that we have this section, this clause 396 discusses the authority of a doctor to prescribe. None of FDA's statements here interfered with the authority of the doctors to prescribe ivermectin. Do you believe it? Again, you could be on the ivermectin for COVID side or against the ivermectin for COVID side. That is not the question here. The question was what FDA was doing and saying, were they authorized to do that? And here they're saying none of the FDA statements here interfered with the authority of doctors to prescribe ivermectin. So I want to go back here for a second. This was the statement and the tweet and the letter. If you have missed that letter last time, let me show you letter, and this is just one. Here is a letter, December 13, 2021, to Humayun Chaudhry, President of Chief Executive Officer, Federation of State Medical Boards. This is from FDA. Dear Dr. Chaudhry, the purpose of this letter is to bring the attention of Federation of State Medical Boards information related to drug products containing ivermectin being offered for sale, which claim that such products treat or prevent COVID-19. And now if I go back here for a second, none of the FDA statements here interfered with the authority of doctors to prescribe ivermectin. Do you believe that this letter here, this letter here, this EMA naming CDC and FDA have issued advisories indicating that ivermectin is not authorized. This why ivermectin should not be used to prevent or treat COVID-19. And they say the Food and Drug Administration echoed the CDC's warnings against the use of ivermectin to prevent. Is this all people just making up things? Because FDA is saying none of FDA's statements here interfered with the authority of doctors to prescribe ivermectin. On page 973 of the record, this is the September 2021 article. So now they're giving examples of articles. FDA says, if your health provider writes you an ivermectin prescription, fill it through a legitimate source, such as a pharmacy, and take it exactly as prescribed. Why this made me kind of amused is they have written the letters. Pharmacists are actually blocking. And now to the public, they're saying, hey, go to your doctor. And doctor prescribes something and the pharmacist says, who are you to do this? Or CVS or Walgreens or many others say, well, we're not going to fill this. But here is FDA. On page 974, FDA recommends that consumers talk to their healthcare providers about available COVID treatment options, and they explain that your provider can help you determine the best option for you based on your health advisory. I think once again, this is now my editorialization. This is quite disingenuous of them to bring up that best options for you. Do you think that in their best options list, ivermectin was one of them? Anyways, so FDA continues. On page 976, this is the April 2020 FAQ. FDA advises consumers not to take any medicine to treat or prevent COVID unless it has been prescribed to you by your healthcare provider and acquired from a legitimate source. So they're saying we didn't do anything. We actually are telling people, go to your doctors. Doctors are going to give you these things. And check this out. FDA is clearly acknowledging that doctors have the authority to prescribe human ivermectin to treat COVID. So they are not interfering with the authority of doctors to prescribe drugs or to practice medicine. Read this statement. This is from, so here, 31 minute, 26 second in the video. This is what they're saying. FDA is clearly acknowledging that doctors have the authority to prescribe human ivermectin. So she's giving those examples to kind of say this. And then here is FDA. Here is FDA. Here is FDA's reference. Here is FDA's reference. Here is FDA's reference. This letter is from FDA. And I showed you Blue Cross Blue Shield last time, the time before that. So this is FDA here. So judge says, I agree there is plenty of statutory authority that empowers FDA to issue information. I don't think there's any question about that. The question is there any colorable authority that authorizes FDA to issue recommendations to provide medical advice beyond information sharing? So judge is still on point. And FDA says, Your Honor, FDA does not need to identify any specific statutory authority to simply speak to the public in this way. And even if Section 396 did apply here, whatever interferer may mean, it can't mean that FDA is barred from sharing its scientific views about public safety dangers. So you can't actually challenge their scientific view because they don't have a process, neither do they have any requirement to be scientific. So they can tag on the word scientific views, words scientific views on any statement, and now they cannot be challenged. And once they tag that on, then they cannot be barred from saying it. That is where the FDA is. So, Your Honor, FDA does not need to identify any specific statutory authority to simply speak to the public in this way. And even if Section 396 did apply here, whatever interferer may mean, because the allegation is that they interfered. So she's saying whatever interferer may mean, it can't mean that FDA is barred from sharing its scientific views about public safety dangers. And what about the scientific views? We saw their argument about their scientific views above. Under plaintiff's theory, FDA would not be able to advise the public that opioids can be highly addictive. Now, the example they're giving, opioid or NyQuil chicken. NyQuil chicken was not an off-label use. It was not prescribed by a doctor. So that is an example that is not fit here. Opioid use, FDA closed their eyes when for years and years, opioids were misused. They never sent any quips at that time. Now they're bringing those totally, for me, they are strange examples for ivermectin. FDA would not be able to advise the public that opioids can be highly addictive and dangerous. It would not be able to advise the public that they should not cook their chicken in NyQuil because this is not a safe use of cough syrup. As another example, FDA has issued a statement explaining that lidocaine, a numbing agent, should not be used off-label for teething babies because this and can cause seizures and deaths in babies. And FDA advised that this was not a safe off-label use of this drug. This kind of advisory should go to doctors. So judge says, but when you say, this is a very important statement, but when you say, should I take ivermectin to prevent or treat COVID-19 and answer no, and it doesn't have all those caveats about the prescription and what all of that because they don't always have the attachments. So she's saying you made the statements without any of such qualifiers, to which FDA said, but the next sentence in that statement says, no, you should not take any drugs unless they've been prescribed to you by your doctor. And just to take a step back, and she continues in a different discussion, which I'll do next time. So here the FDA insisted that one, our views are scientific, but they really do not have a very strong position to stand on why their views are scientific. Secondly, they insisted that we never interfered, and we agree with the authority of the doctor to prescribe even ivermectin for COVID. And they said we didn't interfere. They tried to kind of push back on the court to say, you cannot police us. We can say whatever scientific view is. And then they said we didn't interfere. And I am surprised that they can say this in the presence of all of this. So, anyways, that is the discussion so far. I'm going to stop here for today. There are increasing cases. I'll see if Paul and I can do a discussion about that. Some places there are voices of masking as well. So we'll look into that. Tomorrow I want to finish this one so that this topic is wrapped up. We will do it once there is some more in there. Thank you very much. Like, subscribe, and share. And every single thing that I said here, wherever I said something that was my opinion, I mentioned it. Otherwise, every single thing has the references in the description of this video, and the transcript, which I painstakingly put together, has timestamps on it. So go to the video. The link is in the description. Look at these timestamps and see if what I've written here is, other than the spelling mistakes that were maybe AI issue and me didn't check them, see if what I'm saying here is what FDA and judges said. So with this, thank you very much. I'll see you tomorrow again and we'll close this topic. In the meantime, please like, subscribe, and share. And there is a link in the description if you would like to get access to drbeen.com. Thank you very much, and I would see you tomorrow.